one in Spanish and one in English. The questionnaires help us to know what knowledge people already have when they come to our presentations, so we can better inform our future presentations. This also helps us to obtain future funding for events like this. At the end, we will have another set of questionnaires that are from our funders, who are the Alabama Council on Developmental Disabilities. We are very lucky to have been funded by them for 1 year, and then we were able to get funding again for a second year, which is why we've been able to continue to provide these presentations. So they appreciate any feedback that you can give them on our presentations, good or bad. We do want to hear what you have to say, and we're happy to take that feedback on board for our future presentations. All right, so I am Dr. Christine Drew. I'm an assistant professor at Auburn University, and I do research on challenging behavior for adolescents with intellectual and developmental disabilities. And then I also look at sexuality and relationship education for people with IDD. And I've been very lucky to work with Dr. Doris Hill, and she'll introduce herself now.
Thank you, Dr. Drew. I'm Dr. Doris Hill. I'm an associate research faculty member at Auburn, and I'm the director of the Regional Autism Network. And I just wanted to say, we'll put those links to the surveys in the chat several times during the presentation. And at the end, when we put the SurveyMonkey link in for ACDD, please take the time to fill it out, because it gives them feedback, and hopefully in the future we'll be able to continue doing these kinds of trainings. And welcome for being here today, and thank you to our interpreters, Ms. Jong, Ms. Du for Korean, and Mr. Reed and Ms. Baker for Spanish. So on that note, I'm going to turn it over to Ms. Gutierrez. Oh, and welcome Mr. Williams and Ms. Art, our speakers for today. Go ahead, Maria.
Good morning, everybody. My name is Maria Gutierrez. I am the family navigator for the region number 4. We cover 20 counties, and I know that this is a topic that parents have been asking for. So I am very pleased to have Mr. Lonnie Williams and Maddie Art here from ADAP to share this valuable information, and I hope that you guys found it valuable as well. At the end of the presentation, once we have the recording link, we'll be sending that link for all the attendees, plus the PowerPoint, and the PowerPoint has been translated into Spanish and Korean. So we are very pleased and very happy so that families will have this opportunity and this resource. Mr. Lonnie.
Got it. Okay. Sorry about that. Me and Maddie are in the same room, so we're having to juggle volumes. Can you hear me? Okay. All right. So I'm Lonnie Williams. I'm a staff attorney with Alabama Disabilities Advocacy Program. I've been working with ADAP for about 17 years. I work on a variety of different issues. Everything from wheelchair access to deaf access to treatment of people in institutions to defense of ADA rights, defense of fair housing rights. So I help people try to protect their rights and advocate for their rights. Some of the things that I do also involve things like probate court matters like involuntary commitments and guardianships. And we try to help people avoid guardianships so that they get to retain their rights. And if they're subjected to guardianships, then we try to help them work out problems within those guardianships.
And my name is Maddie. Can you all hear me? Awesome. So my name is Maddie Ard. I am a legal fellow with the Alabama Disabilities Advocacy Program. I focus on voting rights, which it might seem weird at first that a voting rights attorney is talking about guardianships, but I think you'll see in a minute why I care about guardianships and the impact they have on the rights of individuals with disabilities. And with that, I think we can get started. I am going to share my screen. The host has disabled my ability to share the screen. Can someone give me access to that? 1 second, guys.
You should be able, Miss Maddie.
All right, can everyone see my screen? Awesome, thank you. Okay, so this opening slide includes our contact information down at the bottom. The opening title says Alternatives to Guardianship, Alabama Disabilities Advocacy Program, and then Lonnie Williams and his contact information, and then my contact information. I can also include that in the chat. Now, to begin with, I think it's important to explain what a guardianship is, because it's not intuitive. So a guardianship is a legal relationship in which someone is appointed by a court to make legal, medical, and financial decisions for an individual with a disability. At first, that sounds like not that big of a deal. But when you think about it, a guardianship in its purest form is almost like creating a parent-child relationship. The individual with the disability almost takes on the role of a child, while the guardian takes on the role of an adult or a parent, making all decisions and taking away the right of the individual with a disability to make those decisions themselves. You can see how that would be pretty demoralizing for the person with a disability if that's not necessary. I am an adult and I want to make my own decisions. And in a guardianship, that right is taken away from me. I also wanted to point out the Alabama's legal definition for a guardian and a person who is under a guardianship. So the guardian is called a guardian, and that's a person appointed by a court to make decisions on behalf of an individual with a disability. The person with a disability who's under the guardianship in Alabama law is sometimes called a ward or a protected person. We prefer the term protected person or person subject to a guardianship. It gives a little bit more autonomy to the individual. And that's just the person who is under the guardianship or the person being protected by the guardian. So why do we care about guardianships? Guardianships take away a lot of rights from the person with a disability. And that's kind of where I come in as a voting rights attorney. So I've listed just a few of the rights that are taken away when a person becomes subject to a guardianship. Rights removed include the right to determine residence, consent to medical treatment, make end-of-life decisions, like how you would like to disperse your whatever property you might have, or if you prefer to be buried or cremated, things like that. You lose the right to manage your property, to buy new property, or to sell property that you own. You lose the right to own or possess a firearm. You also lose the right to sign contracts, which doesn't sound huge when you think about it, but that's a lot. You lose the right to sign on to an apartment or to sign on to any other kind of property. You also lose the right to file lawsuits for yourself. You have to rely on your guardian to file those lawsuits for you. Because when you, as a person under a guardianship, when you sign a contract or you sign an agreement, it doesn't have any legal effect. You need your guardian to be on board with you. So if your guardian isn't on board with you, you lose the right to protect yourself or protect your rights. Finally, and these two are the scariest, I think, for me, you can lose the right to marry who you want to marry, which you can imagine would be extremely upsetting to somebody who wants to get married if their guardian chooses to stand in their way. And then finally, and for my purposes as a voting rights attorney, a lot of the times when you become subject to a guardianship, you lose the right to vote. I kind of want to point out that sometimes people forget how important the right to vote is. But When you are allowed to vote, you're allowed to participate in your community. You're allowed to state what you care about and what matters to you, and your community listens. So when you lose that right to vote, it's like your community saying, we don't care about your opinion and we're not going to listen to what you have to say. It's a huge blow. It takes away people's autonomy. And for me, it is one of the reasons that I really care about guardianship, and why I think it's really important why people understand that there are alternative possibilities and things that can be used instead of a guardianship that can protect you and save some of these rights. So I do want to point out that there is this thing called a limited guardianship in Alabama law. So what is a limited guardianship? It's a guardianship in which a court specifically reserves some rights otherwise removed upon appointment of a guardian. So basically what that means is that a judge, when you are first subjected, when a judge first says that you are under a guardianship, in that first order saying, now you're under a guardianship, they will specifically outline, but you keep the right to get married, or you keep the right to vote, or you keep the right to buy and sell property. Basically, that list from the previous slide, a judge can mark out like, okay, this right you get to keep, or this right you get to keep, based on an individual's specific circumstances. As of course we know, people with disabilities are just like everyone else. Everyone's situation is slightly different, and there's no blanket situation that is appropriate in every case. So a limited guardianship is designed to accommodate for that reality that each individual is a little bit different, and each individual should reserve all rights that aren't necessary to be taken away for the safety of that individual. So under Alabama law, and this is at Ala Code section 26-2A-105, the Alabama law specifically says that a court shall encourage the development of maximum self-reliance and independence for the incapacitated person, and limit rights only to the extent necessitated by the incapacitated person's mental or adaptive limitations. Now, on paper, that sounds really good. That sounds like Alabama law is requiring judges to look at each case individually and consider the needs of each individual and only take away those rights that absolutely need to be taken away. On paper, that looks really good. Unfortunately, what we, and really what Lonnie, who's got way more experience in guardianships than I do, what he has seen is that most of the time, limited guardianships are not the norm in Alabama. They're not the default. Judges aren't really thinking about them as an option. And it's up to the individuals who are involved in the case or involved in a specific person's situation to bring up the idea of a limited guardianship. The law says that that's not how it should be. It should just be that that is always what a judge is considering. Unfortunately, that doesn't seem like the reality. And the other thing that's important to remember is a limited guardianship is still a guardianship. You're still losing all the rights that a judge doesn't mention in a court order. So this is still a really restrictive situation. It's still a situation where the individual loses a lot of rights that they might not need to lose, or that, another situation, another circumstance, like the alternatives that Lonnie's going to talk about in a minute, might have been able to address without losing all those rights. So while limited guardianship is a step in the right direction, it's not the norm in Alabama, and it still takes away a lot of rights that an individual could otherwise probably keep and be fine. I include this slide just to kind of highlight how serious a guardianship is and how permanent they are. Once an individual is subjected to a guardianship, so once you go through the court proceeding and you end with a judge issuing an order saying, now you're under a guardianship. Once that process is completed, a guardianship only ends in 3 ways. 1, on the death of the individual with a disability. 2, on the resignation of the guardian. Or 3, on the termination of the disability. All three of those are pretty extreme situations. Death is death, so it's pretty severe. And then the other two options, resignation of the guardian and termination of the disability, are both situations that require you to go back to court. It requires the guardian to come back into court, pay court fines or court fees, possibly hire an attorney. It's expensive, it's time consuming, it's a lot of work. And it's why I think in a lot of cases, guardianships don't end, even when they probably should, because it's a lot of work to end a guardianship once they've been established. And so I just wanted to highlight that entering a guardianship is not very easily undone. So people should really be aware of the alternatives available before they go down that road, because once they've created that guardianship, it's pretty hard to undo it. So with that brief overview of all of the different things to consider about a guardianship and what a guardianship is, I'm going to hand it over to Lonnie, and Lonnie's going to talk for a little bit about different alternatives that people should know about and consider if they have a loved one with a disability and are considering guardianship. So let me mute myself so that we don't have a very annoying feedback loop. 1 second.
Okay, can everybody hear me? Okay. All right, well, thank you all for being here. As Maddie discussed, guardianships are a pretty big issue. They cost about $1,500 to $2,000 to get one started. They're pretty expensive. And you're basically involving the probate court in a person's life for the rest of their life. So, you know, we try to help people avoid them while recognizing that sometimes they are, you know, they may be the only tool that can be used in a situation. There are other tools that can be considered. The standard advice that people got for a long time when they were parents of people with disabilities was, well, then when they get old enough, you need to get a guardianship. They were told that for a long time, and so it takes a while to get people to step back from that and say, you know, no, it is not your parental obligation to go get a guardianship. There are other things that you want to consider without paying all this money and without involving the court in your life. So, you know, we'll talk about a few of those. Okay, so the first alternative to a guardianship that we'll talk about is a durable power of attorney. When we say durable power of attorney, durable means that it survives someone's incapacity. In other words, if they sign it and then they lose their capacity to make decisions, it's durable and it survives the person's incapacity. So it's still valid even after they've lost the ability to make decisions. This is an agreement that can be drafted, and let's start out explaining this. It's an agreement. It's like a contract between two people. It doesn't have to involve the court at all. It doesn't take away a person's rights. It simply copies that person's rights and also authorizes another person to exercise those rights. It's kind of like hiring an agent. If you hired an agent, you don't give up all your rights to that agent. You're just letting that agent act for you. And so a durable power of attorney is a contract that two people enter, an agreement that two people enter, so that one person is allowed to act for the other. And they can be carefully drafted so that it only includes certain areas of authority. For instance, it could be drafted so that it only includes medical matters. It could be drafted so that it only includes financial matters. It could be drafted so that it only applies to one specific account or one specific piece of property. So there are different types of durable powers of attorney. You can have a general one, general power of attorney that includes all of a person's decision-making rights, so that one person can make all the decisions that the other person could have made. Another is financial, and another one is medical. So some of the benefits of a durable power of attorney is they don't take very long to draft. You can usually get one drafted in just a couple of hours. And you don't have to go to court and get everybody notified and have them show up, and you don't have to get the court's approval on any of it. You don't have to file it with the court after it's done. Also, once you've given over power of attorney, you can always change it at any time. The most you're probably going to pay for a power of attorney is a couple $100s, if that. And say you made a durable power of attorney today and you decided to withdraw that and name someone else tomorrow, you could do that very easily. So those are some of the benefits of a durable power of attorney. Something similar is called an Advance Directive for healthcare. And an Advance Directive for healthcare, these are very easy to find. Most of your hospitals have them. If the hospital doesn't have them, then the Alabama Hospital Association has them. And they're pretty standard, and they're actually quoted in the law. The document itself is quoted in the law as an advance directive. So there's an example within the law of what an advance directive is. And so these advance directives allows a person to make decisions in advance regarding their health care. They can decide in advance if they want to have nutrition and hydration. They can decide in advance what someone should do if they lose consciousness and are not expected to return to consciousness. They can decide in advance which person is authorized to make decisions regarding these kinds of things, which person is authorized to deal with doctors on their behalf. They can make all those decisions in advance, and so that's why it's called an advance directive for healthcare. There's no court involvement with this document. You just enter into a document and you provide it to all those persons who may need to know. You might want to keep a copy on hand so that can be given to a healthcare provider. These can be, and you can list other specific directions regarding medical care within them. You can change it at any time, so this is even easier than a durable power of attorney. It's going to be free, and they're very easy to find, very easy to execute. A special needs trust. We've talked about a guardianship. There's something similar called a conservatorship. In Alabama, you have a guardianship that deals with the rights over a person, and you have a conservatorship that deals with the rights over a person's property. So if someone has some property, a conservator can be appointed to manage that property for them, to manage their estate, to manage their assets. A special needs trust could be created that would remove the need for those guardianships and conservatorships when So a special needs trust is different than a regular trust. A regular trust will be counted as an asset for purposes of government benefits. If you had a regular trust, it'll be counted as an asset for Social Security purposes. It'll be counted as an asset for Medicaid purposes, for public housing benefits. For all those benefits, it will be counted as an asset. But if you have a special needs trust for a person with a disability, then it is not counted as an asset. Special needs trust is different than a regular trust because that trust can only be used for certain things, basically necessities. So that trust you can put some assets in a trust and still use it for the person, but it's viewed as if that person doesn't own it. But yet that person can use it for things like well, actually, I got it backwards. It can be used for things that are not necessities. So for instance, you can use it for books for school, or you can use it for paying a cable bill. You can use it for taking a vacation. You can use it for all sorts of things like that. Certain furniture. Then there are different rules. So if you were considering whether to do a guardianship or a conservatorship because of a person needed help managing their assets, you can instead do a special needs trust. The benefits of this are, first of all, it's not counted as an asset for government purposes, for government benefit purposes. Second of all, it can be changed without the involvement of a court, and it generally just works better. Let's see. This usually requires the help of an experienced estate planning attorney to make sure that it meets the requirements of a special needs trust, because it has to be drafted a certain way so that it meets the requirements of a special needs trust. Also, some things you need to know is that when you establish a special needs trust, the trust is going to have enough assets to justify paying a trustee for doing the trustee's job. The trustee will decide what gets dispersed from the trust, and they have to be paid for that service. And so a special needs trust usually requires that you have a pretty big amount of assets in order to justify doing one. A lot of banks can help you with this process, and a lot of estate planning attorneys can help you with this process. We have people that we kind of refer people to because we're not very experienced with estate planning and benefits issues. Something similar to a special needs trust, and it's actually a type of special needs trust, is called the Alabama Family Trust. The Alabama Family Trust is operated by an organization that they have all of their own trustees and attorneys. They have like a board that makes decisions, and they do need you to have an authorized representative to make requests and to be available for the handling of disbursements. But the benefit to the Alabama Family Trust is it generally requires less assets than a special needs trust would. There's less cost involved. You don't need an attorney, so you don't have to hire. They do have some minimum initial contributions, and so they take a look at these standards that they have set up, and they change them every so often. But this is a better option if you're talking about a lower amount of assets. Now there's another option that is relatively new. It's been around a few years, but not many people know about it. It's called the Alabama Able Savings Plan. These are sort of like the educational plans that they used to have. where you could contribute money into an education fund and it wouldn't be counted as it wouldn't be counted as assets. But this is the Alabama ABLE accounts. Lots of states have them. Alabama has them. It operates just like a bank account, and you can put any amounts in it, and then those funds can be used for a person's benefit. There are some rules on what it can be used for. You don't have to pay fees for a trustee. A person just uses it just as they would a banking account. I think you can contribute up to $11,000 per year, and so you can contribute a pretty good amount. And there's also like an upper limit, which is usually which will probably change over time. But a person could use an ABLE account and it would not be counted as assets for purposes of Social Security or Medicaid. So this is good for lower amounts. So these are all good options. Another option that's on the horizon that's not a possibility really in Alabama right now. You might could get a judge to consider it if you put together a really good plan, but it's called supported decision making. And supported decision making is kind of like the next frontier of guardianship law. Replacement decision making would be naming a guardian. Supported decision making would be creating a team that would assist a person in making their own decisions. So supported decision making is hopefully what the future holds, because it generates what we want, which is the growth of an individual, the supported growth of an individual. In this process, the person being subjected to a supported decision making team is not treated as someone who has to have all their decisions made for them. There's a team that surrounds them that helps them understand and come to their own decisions. And that team is put together and appointed by a court. So this is this is a cooperation between a person and their team. If this plan were put before a judge, you could say, Judge, we want to put these people together as a decision-making team, a supported decision-making team for this prospective ward, so that they can meet and discuss problems and help the ward understand the problems and help the ward make decisions, and then they would carry out his directives. And so this is a much more empowering option, much more respectful option, and it's better for the individual. As I said, that is not a realistic possibility in Alabama at the moment, because we would, in other states, they're passing legislation that allows for supported decision making. We were hoping that such legislation would be introduced in Alabama in this term, but it was not. But we expect that within the next few years, maybe it will be. So if you hear about this effort and would like to support it, it is an issue that really needs support. Other states are already making progress toward this aim, and we're hoping that Alabama will in the future also. Okay, so let's kind of back up and talk a little bit about all these guardianship issues. We recognize that there may be some situations in which guardianship is the only solution. We try to be realists about that. We hope to help people avoid guardianship at all costs, however, and we are a disability rights organization. So we cannot assist people in helping someone lose their rights. We have to put our resources toward helping people defend their rights. And part of that is helping people have options, and helping them understand what is at stake. Sometimes we run into situations where people are kind of confused about whether a guardianship is needed or not, and we can help them, review the alternatives and see if one of these alternatives would work to solve the problem at issue. Let me give you an example. Let's say a person were 20 years old and they had not yet had their wisdom teeth out, and they have a disability, and they go to the dentist, and the dentist says, I will not take this person's wisdom teeth out because they do not have the capacity to make the decision to let me take their wisdom teeth out. And so the person then has to suffer with the wisdom teeth problems because a dentist will not perform the procedure. And so he may tell the person's parent, you have to go get a guardianship, and then if you are the guardian, then I will let you agree to let me take out the wisdom teeth. And so the parent thinks at this point that they need a guardianship. That may not be true. Okay, so what we're talking about here is informed consent policies of a dentist. We want dentists and other healthcare providers to have informed consent policies, because we don't want people with disabilities to have things done to them by doctors and dentists if there's no informed consent about what's being done, if they don't understand what's being done, if they don't agree with what's being done. We want them to have those policies because there is a long history of in both psychiatry and medicine and dentistry and all these professions of mistreating people with disabilities, doing things to them, and pretending the people with disabilities knew what was happening and agreed with what was happening, when really that wasn't the case at all. So we want them to have those policies. They're good ethical policies. But sometimes they get in the way of a person with disabilities getting done what they need to get done. So let's say the dentist had told you this person needs a guardianship. You might be able to talk with us, and we might be able to do a medical power of attorney, or an advance directive, or something along those lines, depending on what the issue is. We may be able to help you do that as opposed to going and getting a guardianship. And if you go back to the dentist and say, we did not go to get a guardianship, instead, he just made me his agent for dental matters, and here's the document that proves that. The dentist may then say, well, that satisfies our policies. We can now take out the wisdom teeth. Otherwise, you have to wait for that issue to turn into an emergency. Let's say, for instance, we were talking about an appendix. They may have to wait for the appendix to actually rupture before they do the surgery, because they don't have authorization to do it unless it's an emergency. They're authorized to do things that are with or without consent, really, if it's an emergency situation. But if it's a non-emergency situation, they need valid consent. And so that's how these issues often come up. So some of the services that ADAP provides is information and options. We help people decide on alternatives and execute those alternatives and navigate different issues. Sometimes we are available to help people resist attempts to get a guardianship over them, to appear in court for them and tell the judge this person doesn't need a guardianship. We're also available to, once a guardianship is done, to show up in court to try to get the judge to terminate a guardianship. We're available to show up to court to tell a court that well, maybe this person does need a guardianship, but this person doesn't need to be the guardian. Another thing that we didn't mention is, a lot of times parents, when they get guardianships, they don't think about what will happen in the future. Let's say I got a guardianship over my son, and then when I pass away, there's no telling who will be appointed as guardianship of my son. It may be his brother, but then again, it may be a lawyer downtown. It may be the sheriff of that county. There are situations where that has occurred, where the sheriff or some lawyer has become the guardian. And in those cases, they really don't look after the best interests of the ward that closely. We need to think about these eventualities and consider whether there are some things that would work better and be more empowering. And so that's the purpose of these presentations, is to let everybody know about our services and about how serious a guardianship is, and about the other alternatives that are available for consideration. And so we have some links listed here. The WINGS website, that is well, let's see. All right, so there's a couple of websites. There's one, and I think we may have got a mistake on the Alabama WINGS website, but basically the Alabama WINGS initiative is an initiative by the Alabama Administrative Office of Courts. It's like an interdisciplinary intergroup partnership that discusses guardianship and guardianship needs. And so this is a task force that's put together to talk about how to make progress in guardianship law, how to educate judges, how to educate guardian ad litem attorneys, how to educate everyone on the due process that is supposed to be afforded, on the alternatives that are supposed to be available. The Alabama Family Trust website is listed. The ABLE savings account is listed. Information about supported decision making, and of course our website. We've done a lot of work in guardianships, and also there are some situations we look at where we don't do any work at all, but the information we provide is very helpful. For instance, this past week, we had a client that got rejected or evicted from their group home, and a family member got an emergency guardianship over them. And that's where you go to the court and tell them an emergency situation exists and that you need an emergency guardianship. And so the judge will grant you an emergency guardianship and then have the hearing later. So that has already happened to this person. And they got taken out of their group home and taken to live with family, and we weren't sure how that was going to turn out. So we made arrangements to go visit with the client and see how things were going. I don't know that client will decide to resist this guardianship, but we've offered to help them, and we've left our information with them and told them if they, if at some point they want our services, but at the very least, we were able to inform the client about what the guardianship is and what their rights are within that process, and to let them know that we are available should they run into trouble. That's just one example. We've had other examples where people were subjected to guardianships and they didn't even receive any notice that they were being subjected to a guardianship. They were just informed of it. They never got an opportunity to show up in court and defend their rights. Didn't meet their lawyer or anything. And then other situations where a person had a guardian and their guardian passed away, and the court needed to either terminate the guardianship or name another guardian. We've represented people to help them in situations like that. So those are the things that we're available for regarding guardianship.
Lonnie, that's great information. I have been sending the questions as they've been coming to Maddie. So Maddie, I don't know if you will prefer to start answering from the, from the top as you got them. Would that work?
Could you say that one more time for us? I'm sorry.
Yes, so I sent the questions privately to you as they were coming in. So if you would like to read them and just decide who would like to respond to those questions.
And
good.
also, sorry, I was just going to say, and also before we start the question and answer session, I put the links both to the Qualtrics surveys and the ACDD surveys in the chat just a few minutes ago. So while we're having the question and answer session, if you could please fill those out, we would really appreciate it. Thank you.
Okay, so I think the first question might be better for Lonnie. It's, my child is severely impacted by his disability and he doesn't understand how to advocate for his needs. Can a limited guardianship be a better option than a power of attorney?
It can be if the child is able, when they become an adult, if they are able to express their decisions, if they're able to make and express decisions in a certain area of their life. I'll give you a for instance. In the past, we've told the judge that although this person isn't able to make decisions about whether to leave a group home, that they really need the safety and security of a group home, they should be able to make decisions about which group home. If they don't like a group home, they should be able to tell people that I don't like this group home. I want a different group home. Alternatively, we're not saying they should be able to tell people I don't like this group home. I want to go to Hollywood. There's a big difference. So you can make a limited guardianship that gives people rights, but a judge is going to want to hear, why you want to make it a limited guardianship and what your aim is. He's going to want some specifics on that because he has to carve that out in an order. And as Maddie said, they like to treat them as all or nothing propositions. But if you can give them a good reason not to, and reserve some decision-making ability to the person with a disability, that's a good thing. That may also safeguard them later, because even if you're going to try to cooperate with them and make good decisions with them, if you get replaced, the next person may or may not. And also to point out, with guardianship, you don't need one when they're a child. You're automatically their guardian. But when they become an adult, regardless of their disability, they are assumed competent and get all the rights of an adult, and they'll keep those rights unless they're taken away in a guardianship. So a lot of times we'll have people contact us and they'll say, I'm the guardian of I'm the guardian of John Smith. And we will ask, well, what do you mean by you're the guardian of John Smith? And what they sometimes mean is a court has named me guardian of John Smith. They took away all of John's rights and gave them to me. And I have a court order to show that. Other times when they say they're the guardian of John Smith, what they really mean is I'm John Smith's SSI payee. Or they mean I am the parent of an adult child and you know, with a disability, but no rights have been taken away. Or they may say, they may mean I'm the caretaker of this person. I'm the person who takes care of this person, but that doesn't make them, you know, guardian. A guardian is an actual court order from a court that deals with taking away an adult's rights and naming another person.
Okay, so the next question is, how can an individual keep his voting rights if he has a severe disability and doesn't understand political views? Do people with disabilities actually have a right to vote? So this is a me question. Yes, anyone who is over the age of 18 has a right to register to vote if you're an American citizen. That is not something that when you are registering to vote, you have to say if you are mentally competent. But mental competence for voting purposes is not based on whether you have a diagnosis or not. Mental incompetence is something that only a judge can determine. You as the parent don't have that right. A doctor doesn't have the right to say that someone is incompetent to vote. The only person who gets to say that legally you cannot vote is a judge. So if someone has never gone before a judge and that judge said, you can't vote, you can't vote, you can register to vote. I think this is a common question. It's a common concern that people who don't have disabilities have, that if I can't form political opinions, should I be allowed to vote? The thing that's important to remember is that I am a person who does not have a visible disability, and I don't have an intellectual disability, and I don't have a developmental disability. So no one has ever questioned whether or not I can vote. No one's ever questioned if I can form political opinions. And it could be that I can't. It could be that I voted for John Doe because I liked the shirt he wore during a debate, or I voted for, you know, Jane Smith because I like the color of her hair, or I like her name. I don't get questioned on whether or not I can form opinions because I don't have a diagnosis that impacts my intellect. But for other individuals who have learning disabilities, intellectual disabilities, developmental disabilities, they're questioned on those things. And, you know, I think it's important to remember that everyone is assumed to be competent, or should be assumed to be competent, and that you shouldn't be forced to prove that because of a diagnosis. We all have a fundamental constitutional right to participate in the political process. And that is something all constitutional rights, all fundamental rights, including the right to vote, are rights that should not be taken away unless it's absolutely necessary. And like I mentioned, each disability is different. So, you know, someone with an intellectual disability might have a different concept of the election process than someone with schizophrenia, or somebody who has a developmental disability, or someone with a physical disability. It's important that this isn't something we can't just say everyone with a disability doesn't get to vote, because that would take away a huge percentage of the American population. So it's important to remember that you, as someone without a disability, aren't questioned, and people with disabilities deserve that same right, and that you only lose the right to vote if a court specifically says you are not competent to vote, and then you lose that right. I know that that is kind of lofty and maybe a little bit confusing. So if you have any other questions about voting rights, and if you have a loved one who you are concerned about whether or not they've lost the right to vote, or if they need help registering to vote, or if you've got questions about how you are allowed to help them, I am here to answer any questions in that realm. So please, I know that our email addresses have been included in the chat. Please reach out to me, and I'm here to help and answer any more questions that you might have related to voting rights. And I know that we're butting up on 11 o'clock, so do we want to continue answering questions? Or Ms. Gutierrez, would you prefer that we hold off for now and maybe answer other questions through email?
Well, if you guys still are available, I mean, it's up to you. I mean, I know that there are a lot of questions coming. So if you guys still have some time, I mean, Lonnie, can you guys still go for a couple of minutes, or?
Okay, so just to cover a couple of questions I've seen. The judge makes the decision about who is named as guardian. He usually likes to have people who are in a position to know about a client and to keep up with their welfare. He's supposed to go by an order of preference that starts with family members like mother, father, spouse, child, those closest. They're supposed to get preference. I don't know of any prohibition regarding nationality or citizenship that would prevent someone from being subjected to a guardianship here or from being named as a guardian here. I don't know that that is a requirement for either. I don't think that would be a hindrance or a requirement. If it does come up, we have friends that do work on immigration law that we could contact and ask them how to navigate that issue, since that's not one that we've really dealt with before. As far as the age for getting a guardianship, that generally happens at age 18. A person in Alabama gets some decision-making rights at 18 and gets full decision-making rights at 19. For instance, if you're 18, you can enter into certain contracts, but not others. If you're 18, you can make certain decisions, but not others. But when you're 19, you're a full-fledged adult. So most people get a guardianship around the age of 18. Let's see. As far as for getting help getting a guardianship, as we mentioned, we're not able to help people get guardianships, but we can refer you to other sources of assistance. If you contact us and let us know what area you're in, we might could suggest someone potentially. But again, those services are not going to be free. The going rate for those kinds of services is about $1,500 or $2,000, because you have to pay for that lawyer's work, and for the court fees, and for the guardian ad litem fees, and the court representative fees, and so there's not any free service that will assist you in getting a guardianship. It's going to be costly. So those are the ones that I noticed on the screen. I'm not sure if there are any other ones that I could get to quickly.
There's this question regarding, so can a guardianship be someone that doesn't have a USA citizenship? And what if the person lives outside the country?
So a jurisdiction for a guardianship is wherever that person can be located. If a person is here if a person's just passing through, a judge may not take jurisdiction of that person's situation. But if a person is here, if they're living here, the judge of that county can take, can assume jurisdiction of that matter. And that's even if the person is not a citizen of the country, as far as I know.
And another
Another question. Oh, sorry.
No, go ahead, Mari.
Another question that I think could be answered very quickly, and that you, Lonnie, might have some expertise in, is there a specific disability that is applicable for a power of attorney?
I mean, there's not any specifics on it, and for that matter, special needs trusts, either one can be used for anyone with any disability, or with a power of attorney, it can be used for someone with no disability at all. It could be, say for instance, if you or I wanted to give someone durable power of attorney, we could. So one of the issues that may come up if you try to execute a durable power of attorney is whether or not the person understood what they were executing. That is a consideration. So if I'm drafting a power of attorney for someone, and I want to sit down with the person that I'm drafting it for and make sure they understand what we're about to do, and that they are in agreement with what we're about to do. That they don't have to understand all the little details, but they have to have some kind of understanding. For instance, with those advanced medical directives, the advanced directives for healthcare, they may not understand what a heart surgery is, but they may understand that they want mother to make all their decisions about heart surgeries. Does that make sense? And so we try to gauge whether or not, the person, whether we are being responsible in assisting the person to execute these documents, because they can be called into question later. If a person already has a guardianship and they try to enter into a contract or a power of attorney, then that document is void. But you have situations in which contracts and documents can be treated as voidable. In other words, people can challenge them and say they didn't have a guardianship, they entered into this contract, and they didn't have the capacity to enter into this contract, and we want the court to declare it void. That would be avoidable, and that's the reason why some people will try to get guardianships, is to keep people from getting tricked into contracts. But you can always go back later and have those contracts declared as void if that becomes an issue.
There's one more that if we have time, think could be helpful. And that was, who can be a part of a support team for decision making? Can family members count? Can siblings count?
I don't think there's any restriction on who can be part of a team. Just whoever would be helpful in the decision-making process. It could be family members, it could be friends, it could be case managers, it could be other professionals. Whatever composition the court wants, whatever composition that people want to present to the court. There's not any restrictions on it, really.
And someone asked about where can you access an advance directive? Lonnie, correct me if I'm wrong, but that's something that we at ADAP could help you set up.
Yeah, we can provide you with a copy and even help you execute it if that's required. Also, there is a standard form available on the website of the Alabama Hospital Association.
Lonnie and Maddie, I have a question regarding if you guys know of an organization similar to ADAP where they could have this kind of information in Tampa, Florida?
Yes, we have so we're a federally appointed, federally funded disability rights organization, a federally funded protection and advocacy agency for people with disabilities. And we're part of a parent organization called the National Disability Rights Network. And the National Disability Rights Network has affiliates in every state and territory in the country. So there's Alabama Disabilities Advocacy Program covers the whole state of Alabama. Disability Rights Florida covers Florida. The Georgia Advocacy Office covers Georgia. So each state has its own disability rights organization. We have sister agencies in every state and every territory.
I just added in the chat a link to the Disability Rights Florida website. They can be really helpful. We worked with them a little bit in the past.
And I know that parents sometimes they ask themselves about what is really the legal age in Alabama, and if there is a place where we could find like what are their rights when they are 18 and when they are 19. Is there anywhere where parents could have access to this information, and can you guys provide us with what is the accurate legal age for individuals in Alabama?
I've never found like a one place to get all the information on that, but I haven't really done a lot of looking, for like a graph or something like that that would lay all that out. Generally we take it on a case by case, topic by topic thing. For instance, if you were 18 and you tried to enter a lease for an apartment, you would not be allowed to, because you can't be held to that contract, and so the landlord would not want your signature because it's no good. He can't hold you to it. He can't. If he allowed you to rent, he could not say that you're liable under it because you were not able to obligate yourself under it. So that's just one example, but but can you set up a bank account? I don't know. We could find out those questions. We could research those questions if you had a particular topic. But as far as a one-stop place or a graph or that covers all those issues, I don't know of one. There may be one out there.
And I've seen several questions in the chat that are asking about specifics about, your situation or like your relationship with your child or a loved one. And without a lot of information, we don't want to give you a blanket answer just because we don't know the specifics. So if you are questioning whether or not you should consider a power of attorney or a guardianship, we won't be able to help you if you choose to set up a guardianship, but we really encourage you, if you have specific questions about a loved one, to reach out to Lonnie is probably the better person to reach out to directly, but you can also reach out to me, or if you would prefer, you could call our front office and set up an intake. But either way, I would really encourage people who have specific questions about their specific situation to reach out to us individually so we can get some more information, so we can give you an accurate answer and the best answer for your situation.
And let me also say, because of the way that we're funded, we can only, our clients have to be people with disabilities, not the parents of people with disabilities. So we often provide information to parents. We often, provide referrals to parents. We often help them navigate things, but in order to actually provide an actual service, we would have to receive authorization from the client themselves, the person with the disability themselves. We are only able to act at their direction in accordance with their wishes. So, before we could draft anything or help anybody enter into anything, or appear on someone's behalf, we would need to talk with the potential client and get their authorization for those things. Now it's different when they're a child, but when they're an adult, we have to be client directed.
And Lonnie, actually, this is a question for you. Do we currently on staff have somebody who is able to interpret in Spanish? And if we do not, I know that we can secure interpreters, but is there someone on staff that speaks Spanish?
I think so. I don't know how proficient. I haven't ever inquired, but we will make the arrangements that need to be made. I haven't really asked that question yet, but we will make that happen. If we make sign language interpreting happen all the time. I'm sure in the past we have made alternate language interpreting happen. I've heard of other people on staff that have provided that have arranged that, and so that would not be difficult for us to do. It would not be, it would not be the first time, and there would be somebody here who's experienced with setting that up that could help me set that up.
Maddie, I don't see any other questions. I don't know if you guys saw this one where it says that can a judge deny guardianship? And if so, can the parents appeal? I don't know, maybe you answered that one and I didn't get it.
Okay, so I wanted to kind of back up on the interpreting thing. One of my hesitations on the interpreting thing is, if I get a sign language interpreter, I can't just get a sign language interpreter. I have to get a sign language interpreter who is able to talk about legal matters, court processes and things like that. And so that's, they have to be a little bit specialized. I'm not sure if it's the same way with alternate language. So I think we have someone on staff who does speak Spanish. Whether or not they speak Spanish relating to legal matters, I don't know if she would be comfortable doing that. So that's my hesitation on it.
Well, we can secure an interpreter outside. So if they want to just call to like do an intake, our person who does intake should be able to manage that. And then for anything beyond that, she could secure an interpreter.
Yes. And I'm sorry, what was that question that you had again, Maria?
The question was if the judge could deny the guardianship, and if so, can parents appeal?
So most people approach the probate court of the county. You can also approach the circuit court of the county. Both of them have concurrent jurisdiction. The circuit court of the county also has appellate jurisdiction for denials by the probate court. So if the probate court, whatever the probate court does, the circuit court can be asked to review it.
And that being said, I don't think we've seen a lot of situations. I mean, Lonnie, correct me if I'm wrong. I don't think we've seen a lot of situations where a guardianship has been denied when you have like the proper, like all your ducks in a row. That being said, remember, we would prefer that people use other alternatives to guardianship instead of a guardianship.
I do not see any other questions, but I would like to invite our participants that if they do have any other further questions to reach out directly to ADAP and Mari and Lonnie to ask their questions and ask for some counsel. So I think that this was an excellent presentation, very informative. I know that this has been one of the topics that parents and professionals have asked us to have speakers come in and present. Dr. Hill, Dr. Drew, is there anything that you guys would like to add?
I was just going to say thank you to both our speakers, Miss Maddie and Mr. Williams. We appreciate you being here today. And if you haven't filled out the surveys, please do that. That's important to us, getting your feedback and providing feedback to ADMH, I'm sorry, ACDD, who funded this opportunity for us. And also, again, to thank our interpreters, Ms. Chung and Ms. Du for Korean, and Mr. Reed and Ms. Baker for Spanish. And we have some upcoming trainings next month. We'll be on early intervention, and then we also have one coming up in May. So be on the lookout.
Also, I will be sending the PowerPoints, the information that it was presented today, along with the recording link for you guys to view it at your own pace later on. And I will be sending also, if you didn't have an opportunity to fill out the surveys, I will also be sending the links. So Dr. Drew, is there anything else that you would like to say? But I do want to say, Lonnie and Maddie, I really appreciate that whenever we have reached out to you guys are always available to come and present for our families. And I really appreciate ADAP very, very much.
Thank you very much. We're so glad to have had the opportunity. I am sharing in the chat our website and the information to call our front desk. And I want to just reiterate again, if you guys have specific personal questions or experiences that you want to talk to us about, I really, really encourage you to call us, and we are happy to help.
And I just want to echo my support for ADAP. I've had really excellent interactions with the folks that I've worked with so far. And I know the parents that we've worked with have really appreciated having the extra support. And this is excellent information. And I learned a lot today. And so I feel like I have some other folks that may want to benefit from a guardianship talk in the future. So you two may end up being drafted again. So sorry for your for that.
We can handle it.
I have no doubt. I have no doubt. Thank y'all so much.
Thank you.
I think we can stop recording now, Maria.